This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
Hey, I'm Jamie Carper, and today we're talking about money, speech, and fairness in elections. The case is Davis v. Federal Election Commission, 554 U.S. 7242008 at issue, a 2002 law Congress passed known as the Millionaire's Amendment. This was part of the Bipartisan Campaign Reform Act, also known as McCain-Feingold. Most federal candidates and their political parties are limited in how much money they can receive from individual donors. But Section 319A of the law said something different if one candidate spends a whole bunch of personal money on the candidate's campaign. Under this Millionaire's Amendment, if a candidate self-funds and spends over $350,000 of personal funds, their opponent could suddenly receive much larger contributions than normal and benefit from unlimited coordinated party spending. Also, the self-financing candidate had to file extra disclosures. Enter Jack Davis, a wealthy Democratic candidate for the U.S. House of Representatives from New York. Davis had run self-financed campaigns before and planned to do so again. He sued, saying the Millionaire's Amendment burdened his First Amendment free speech rights and created unequal rules for candidates competing for the same seat. In the district court, the FEC won it, said the law didn't burden Davis's speech and that the reporting requirements were no worse than others already in place. But Davis appealed, invoking the law's exclusive avenue for appellate review, bypassing the D.C. Circuit Appeals Court and case directly to the Supreme Court. So, the big questions before the court were, first, does this asymmetrical campaign finance scheme burden political speech protected by the First Amendment? Most importantly, does it impermissibly discriminate among candidates running against each other? And if so, is there any justification for it?
We'll hear argument in Davis v. Federal Election Commission.
Mr. Chief Justice, and may it please the court. Section 319 imposes different rules for candidates who self-finance versus those who do not. It penalizes a candidate for spending his own money, a core form of political speech. By raising contribution limits for the opponent, it burdens the self-financing candidate's ability to advocate for election. This is an unprecedented restraint incompatible with the First Amendment.
Are you saying the statute actually punishes you for speaking with your own money?
Exactly. In Buckley v. Valeo, the court recognized that using personal funds to advocate is protected political speech. Forcing a candidate to choose between self-funding and unequal fundraising is a burden on that speech.
Mr. Chief Justice, and may it please the court. The statute does not stop anyone from spending personal funds or from speaking. It enlarges access for the opponent to balance the influence of wealth. A valid governmental objective. It is about fairness in elections.
But is that balancing consistent with the First Amendment's protection for political speech?
Congress must have leeway to craft rules to preserve fairness and to prevent corruption, or the appearance of corruption.
The court should reaffirm that money is speech, and any law that burdens political speech must be closely scrutinized. Section 319 imposes asymmetrical burdens. One candidate faces tougher fundraising rules because he chooses to spend his own money. That's unconstitutional.
But Congress acted to level the playing field. Doesn't that further speech overall by encouraging contributions to the non-self-financer?
The First Amendment doesn't allow penalizing speech for the sake of leveling. There's no compelling corruption rationale here.
This is a close case, but the asymmetry worries me.
Political equality concerns do not justify discriminating against one speaker's rights to advocate vigorously for election.
Justice Alito has the opinion of the court.
We hold that Sections 319A and 319B of the Bipartisan Campaign Reform Act, the so-called Millionaire's Amendment, violate the First Amendment by imposing an asymmetrical burden on the political speech of self-financed candidates. The statute's attempt to equalize electoral opportunities cannot justify discriminating among competing candidates' speech rights. The judgment of the district court is reversed, and the case is remanded for further proceedings consistent with this opinion.
All right, here's what the Supreme Court actually did in Davis v. Federal Election Commission. By a narrow 5-4 vote, the court struck down the so-called Millionaire's Amendment. Writing for the majority, Justice Alito said the law violated the First Amendment because it imposed unequal campaign finance rules on candidates running for the same office. The majority held that a candidate has a constitutional right to spend unlimited personal funds on their own campaign and that the government cannot burden that choice by giving the opponent higher contribution limits and special advantages. In the court's view, trying to level the playing field by penalizing self-funded candidates is not a valid justification under the First Amendment. In short, the majority said, you can't fix inequality in elections by disadvantaging one speaker. Now, this was close, very close. Justice Stevens, joined by Justices Ginsburg, Breyer, and Souter, strongly disagreed. They argued that the Millionaire's Amendment did not silence anyone. It didn't cap spending. It didn't ban speech. Instead, it expanded speech by giving non-wealthy candidates a fairer chance to respond. The dissent warned that the majority treated wealth as constitutionally untouchable speech power, while ignoring the real-world distortion money creates in democratic elections. Congress, they said, wasn't punishing speech, it was responding to the structural imbalance that allows personal fortunes to drown out ordinary voices. Justice Stevens put it plainly, the Constitution does not require the government to remain passive while elections become dominated by personal wealth. So, here's the takeaway. The majority doubled down on a principle that money spent in elections is protected political speech, even when that protection locks in inequality. The dissent saw the case very differently, as a missed opportunity to let Congress protect democratic competition without censoring anyone. Davis v. FEC didn't just strike a statute. It reinforced a constitutional vision where formal equality of speech outweighs concerns about actual equality of participation. I'm Jamie Carper, and remember, when the court splits 5-4, you're usually not just seeing law, you're seeing two very different ideas of democracy collide.